My presentation is on the state of North Carolina, focusing primarily on the House Bill 2 that was recently passed in 2016 by the North Carolina General Assembly. The purpose of this presentation is to highlight and describe the act to provide for single-sex, multi-occupancy bathroom and changing facilities in schools and public agencies to create consistency in regulation of employment and public accommodations, also known as the Public Facilities Privacy and Security Act, or more simply as North Carolina's House Bill 2, or HB 2. This presentation will first give background information regarding this bill and provide a history and underlying circumstances of the establishment, passage, and enforcement of HB 2. Next, this presentation will describe and discuss civil, legal, and political issues that are causing much controversy surrounding this piece of legislation. To fully understand the problems that HB 2 has caused, it's necessary to capture the timeline that pertains to the unfoldment of the legislation. LaCour provided a useful synopsis of this evolution in his work. His timeline began April 29, 2014, where the U.S. Department of Education's Office for Civil Rights published guidance on sexual assault for schools that receive funding through Title IX, the 1972 civil rights law that prohibits many forms of sexual discrimination. This document explicitly suggested that Title XIX sex discrimination prohibition extend to claims of discrimination based on gender identity or failure to conform to stereotypical notions of masculinity or femininity, and that the actual or perceived sexual orientation or gender identity of the parties does not change a school's obligation. This created many questions regarding gender and sex throughout the country. North Carolina became aware of this change in their own state government and decided to act and react to this federal proposal. Throughout 2014 and 2015, the LGBTQ movement was picking up full steam throughout America. In Charlotte, North Carolina, in early March of 2015, the Charlotte City Council held a public hearing before voting to add special clauses to a city ordinance that protect gay and transgender people. The firestorm began with this meeting as the specific proposal to allow transgender people to use public bathrooms according to the gender with which they identify created unease for people worried about sexual predators committing heinous crimes in public bathrooms throughout the city of Charlotte. The beginning of 2016 began to demonstrate the polarization of the issue in North Carolina and in America in general. National Republicans put forth efforts to rescind the Department of Education's interpretation of Title IX. The issue became a hotly debated topic in North Carolina and throughout the nation. The polarizing Charlotte ordinance would become even more influential as the North Carolina House of Representatives would have their voices be heard on the subject, which would eventually lead to the creation of House Bill 2. In late February of 2016, the City of Charlotte City Council held another public hearing that would begin the much-heated feud between factions of those who believe transgender people should adhere to the gender on their birth certificate or the real sex, or in those who believe that gender can be chosen. The North Carolina House Speaker Tim Moore stood firmly against the protection of transgender people in the form of public bathroom rights and worked hard to create and enact and enforce legislation that would not afford gays and transgender people extra protection from the law. The governor of North Carolina became visible in the political argument in March, soon after the call for HB 2 in February. On March 23, 2016, the North Carolina General Assembly passed House Bill 2 that effectively, according to Lacombe, forces transgender men to use women's rooms and transgender women to use men's, allows private businesses to discriminate against gays and transgender people, prohibits local governments from preventing such discrimination, prohibits local governments from setting any employment standards, including minimum wage, for businesses they hire as contractors, and jeopardizes $4.6 billion in federal Title IX funding for schools. Governor McCrory became a supporter of the bill when he authorized it with his signature and created a new level of dispute within this controversy. Soon, businesses and entertainers began boycotting North Carolina in protest against House Bill 2. In April, the Fourth U.S. Circuit Court of Appeals in Richmond, Virginia, which holds jurisdiction over the state of North Carolina, ruled in favor of a transgender teenager in Virginia for gender identification when using the bathroom principle. The court said the school which prevented the transgender teen from using his chosen gender in his bathroom choice was in violation of Title IX and violated the person's civil rights. The court's decision began a call for the repeal of House Bill 2. The Justice Department's Civil Rights Division became explicitly involved in this dispute when it contacted Governor McCrory to respond to the violation of civil rights supposedly contained in this controversial bill. In early May, Governor McCrory responded to the federal inquiry with a lawsuit that seeks a ruling that HB 2 does not discriminate unfairly. The Justice Department filed suit right back against the state that it violated Title IX in its enactment of HB 2. Throughout this past summer of 2016, the saga continues to develop and escalate. In July, the governor signed into law minor changes to HB 2 that restored the rights of employees to sue if they feel they've been discriminated at the state level. The National Basketball Association became political when they announced they were pulling their 2017 Exhibition All-Star game away from Charlotte due to this legislation. North Carolina Governor Pat McCrory reacted by issuing a statement that said the sports and entertainment elite and others had misrepresented our laws and maligned the people of North Carolina. To start with, then, it is worth pointing out that North Carolina legislation in question here, HB 2, was specifically passed in order to override an ordinance-level law that was passed within the city of Charlotte. According to the new HB 2 that was passed at the state level, transgender people who have not taken surgical and legal steps to change the gender noted on their birth certificates have no legal rights under state law to use public restrooms of the gender with which they identify. Cities and counties can no longer establish a different standard. The Charlotte law essentially said that a born man who now identifies as a woman or vice versa could use public bathrooms in accordance with the gender with which they now subjectively identify. The North Carolina state overruling, however, states that this will not be possible and that people identify as transgender must use the bathroom that matches up with their born gender. An important point here is that North Carolina HB 2 legislation does not, in fact, deny the reality of some persons being transgender. Rather, it simply defines what it means to be transgender in a very narrow way. As Wallace has written, transgender persons who have undergone sex reassignment surgery can use the bathrooms based on their reassigned gender because North Carolina permits such persons to change the gender on their birth certificates. In other words, if a born man has actually had surgery to anatomically become a woman, then North Carolina still recognizes that now woman's rights to use the women's bathroom. The law, however, prohibits transgender persons from using the bathroom of their choice on the grounds of their own subjective identification, basically on the grounds that such identification is not actually enough to qualify the person in question as transgender at all. Moreover, the HB 2 law applies to public facilities. It is indicated that private stakeholders and businesses can still make whatever policies they would like regarding the usage of bathrooms by transgender persons. When this is combined with the fact that the law does not actually include restrictions on transgender persons who have in fact had surgery, the issues under consideration here clearly become more ambiguous and complex than one might imagine by reading sensationalized headlines. There are clearly civil rights issues involving the treatment of the transgender population at play here, but there are also issues regarding the rights of people who, in the absence of HB 2, would be expected to share bathrooms with people who are still anatomically of the opposite gender. An obvious point that can be made regarding North Carolina's HB 2 legislation is that it is a significant affront for the rights of the transgender population. More specifically, it places significant limits on the capacity of a given person to determine his or her own gender identity. The law essentially indicates that unless one has had actual surgery to become the opposite gender, one is not actually transgender as far as society is concerned. This means that even a man deeply feels that he is a woman, or a woman deeply feels that she is a man, this would hold no water whatsoever in the terms of how they are treated in society in general, and in terms of what bathrooms they can use at public facilities in particular. HB2 means that a person's subjective identification as transgender is not enough to make him or her transgender. Rather, the law establishes the objective criterion of the person in question having to have had actual anatomical surgery to make him or her the opposite gender. From the perspective of the current federal government, Washington, D.C., the North Carolina's HB2 bathroom bill is in flagrant violation of federally insured civil rights legislation that protects the rights of minorities, including the transgender population. From the civil rights angle, then, which is primarily concerned with ensuring the rights of minorities over not being trampled by the prejudices of the majority, North Carolina's HB2 law clearly appears as a regressive piece of legislation. The role of House Bill 2 becomes more obvious when the details of the legislation are examined to determine what is really offered. Opponents of the bill suggest the bill is very anti-gay and transgender and promotes hatred against these groups. This argument could be countered by pointing out that gays and transgender people have access to their own individual, non-gendered bathrooms that must be made available according to the law. The law goes out of its way to point out that even though it requires men to use the men's room and women to use the women's room, single occupancy restrooms can be used by people regardless of their biological gender or of the gender they identify with. Schools and places of business have the option to make those single occupancy areas available to individuals who aren't comfortable in public, private spaces assigned to their biological gender. The political nature of House Bill 2 becomes more prominent when examining the very high-profile actions that have taken out against the state of North Carolina. Very orchestrated and deliberate actions have been made public against the state and its people to deliver political statements regarding the principles involved with the case. The high-profile nature of this discussion suggests that there are more players involved with this case that is currently known. To highlight the national and international prominence this discussion has brought upon itself, the following list designates those who have boycotted the state in one form or another. Ringo Starr, Bryan Adams, Deutsche Bank, Bruce Springsteen, PayPal, Michael Moore, General Electric, NBA, Dow Chemical, Hewlett-Packard, Pepsi, Choice Hotels, Lionsgate, NCAA, Microsoft, Apple, Wells Fargo, Google, Levi's, HP, IBM, Starbucks, to name a few. There are a myriad of legal issues associated with House Bill 2, and the manner in which the federal, state, and local governments related to this case are very confusing and possibly unsolvable in a legal manner. The economic fallout and legal discrepancies related to House Bill 2 and the perceived violation of civil rights on certain people have created problems that supersede the seemingly minuscule ideals related to privacy and bathroom use. From the federal point of view, North Carolina is in violation of Title IX that makes discrimination a possible crime to the violation of human rights associated with the action. According to the argument in the Equal Protection Clause, there must be a substantial government interest in order to mandate such laws. In a recent court hearing regarding HB2 in August, this legal idea was addressed. Federal Judge Thomas Schroeder ruled on the legality of House Bill 2. His ruling did advance some arguments, but also continued to allow for legal debate to continue. The idea of gender was addressed in this ruling, but at the same time did not disallow the bill itself. Schroeder then writes that the question of whether HB2 is substantially related to that interest requires him to decide whether sex means physiological differences between men and women or differences in gender identity. Schroeder decides that the Supreme Court defines sex as physiological differences in United States v. Virginia when it ruled that women must be allowed entrance into the Virginia Military Institute. He also found that 99.7% of Americans' biological sex aligns with their gender identity. Because the law classifies individuals with 99.7% accuracy, he writes it is a reasonable fit and satisfies intermediate scrutiny. This court ruling does little to remedy the debate, yet provides new arguments to fuel the fire on both sides. An exercise in politics got caught up in politics. Charlotte City Council wanted an ordinance sought by LGBT voters, and finally, after a recent election, had a majority to adopt it. Most important was extending anti-discrimination based on sexual preference and gender identity. Then against cautionary advice from legislature, the governor, and even supportive editors, they went one bridge too far. They added a right for transgender folks to use a bathroom of their choice, which they were probably already using. What happened next was predictable and forewarned. The North Carolina General Assembly called a session to halt the ordinance before it took effect. Once House Bill 2 to repeal the bathroom ordinance was open for amendment, strange things happened. Amendments that could have been taken up later were moved and approved with little debate or understanding. The federal courts could overrule HB2 depending frankly on which set of judges hears it on appeal. By the time it reaches the Supreme Court, it may again depend on the presidential winner. The saner course would be for the General Assembly to take up this issue, which it has effectively tabled, conduct thoughtful hearings, and work out a reasonable balance of interest. The Supreme Court of the United States has recently announced it will hear the case of GG versus Gloucester County Public Schools, deciding on the right of a transgender teen to use appropriate bathrooms next year. SCOTUS hearing this case could lead to the securing of LGBTQ rights beyond just the context of bathroom use. But if SCOTUS does find in favor of the transgender student, North Carolina's HB2 will be effectively invalidated.